Kaya kuranga tira, tēnā tātou katoa. Ladies and gentlemen, just by way of brief explanation, if I may, on auspicious occasions such as this, the university would normally have in attendance our kaumātua, Mr. Tāmati Tata. Matua Tāmati is currently outside of Tauranga, attending to other university business. So as the university campus director of operations, it's my privilege and obligation to welcome you all here this evening. So, tēnā tātou katoa. He honore he kororia ki te atua, he maunga rongo ki te whenua, he whakaaro pai ki ngā tangata katoa. Āmene. He wehi ki te atua, te timatanga o te whakaaro nui, ko aua whakamoemeti, aua whakawhetai, tukua, kia whakahonore tia tōna ingoa tapu. Ka tahuri atu rā ki ngā mate huhua o te wā, kia rātou ko hipa atu i te tirohanga kanohi. Ko tā Toby Curtis tērā, ki roto iti, ki runga i te marae o rā kaiao. Ko te rangatira, ko Piri Kohu tērā, ki runga o Huria Marae i ngai tamarā waho. Ko ngā mate katoa i kawea ake, ki runga o tūranga waiwai i tērā wiki i te wā o te koro neihana. Rātou katoa, ka mihia, ka poroporo aki hia, ka tangi hia. Nō reira, ko taua kōrero rā anō, rātou kia rātou, tātou, te hunga ora kia tātou, nā reira e raurangatira mā, tēnā tātou katoa. Tēnā tātou, me ngā mihi ki te kingi Māori, kia kingi tū heitia pō tātou, te whirowhiro, te tua whitu, tōna whariariki, pai marire kia rātou katoa. Ka tahuri, ki ngā iwi o tauranga moana, kia Ngāti Ranginui, kia Ngaiterangi, kia Ngāti Pūkenga, tēnei, tō koutou whare wānanga e mihi atu ana. Matua Charlie, pari, koutou e pupuru nei i te mana i te mauri o te whenua o te moana, tēnei te whare wānanga o Waikato e mihi atu ana ki a koutou. Tauranga moana, tauranga tangata, tauranga herenga waka. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ka tahuri atu rā, ki te kōmata. Ki te kōmata o te whare wānanga o Waikato, kia koe Chancellor, Sir Anand. Tēnei tō whare wānanga, e mihi atu ana ki a koe. Tēnei tō whare wānanga, e mihi atu ana ki a kōrua, ko Lady Susan, ko tai mai nei, tēnei pō, ki te kaue ake, ki te hāpai ake i te kaupapa, tēnei ka mihi atu rā ki a koe, ki a kōrua. Ka tahuri atu rā, e raurangatira mā, ki a koutou katoa. E koro mā, e kui mā, koutou ngā pakeke, ngā whāia, ngā mātua, nau mai, haere mai, te tini, te mano, ngā kārangarangatanga katoa, nau mai, haere mai, ki te whare wānanga o Waikato, te whare wānanga o Waikato, e tuana ki tauranga moana, he koanga ngākau, ki te kiti atu i a koutou, nā reire raurangatira mā, nau mai, haere mai, nau mai, haere mai, tēnā koutou, tēnā koutou, tēnā koutou katoa. Ladies and gentlemen, we acknowledge the inspiration and the guidance from above. We acknowledge those who have recently departed, including Sir Toby Curtis of Te Arawa and Matua Piri Kohu of Tauranga Moana. We acknowledge the Māori King, who recently celebrated 16 years on the throne of the Kingitanga. We acknowledge also te kōmata o te whare wānanga, the university's Chancellor, Sir Anand Satyanand, who is here this evening. And of course, we'd welcome all of you who have come along to this very auspicious occasion this evening. It's a great pleasure for the university to be alongside Mackenzie Elvin Law as the co-hosts this evening. And it is my pleasure to now invite the Dean of the university's Faculty of Law, Professor Alpana Roy, to extend the welcome. Tēnā tātou.
Ena mana, ena reo, tine te mihi, te piringa ki a koutou, ki a koutou, ki nā koutou, tina koutou katoa. Kia ora, thank you very much for that very warm mihi, Joseph, and thank you all very much for attending this very special event, our 2022 Te Hūnga Faculty of Law and Mackenzie Elvin Law Public Law Lecture. My name is Professor Rt Hon Rōia, Dean of Te Hūnga Faculty of Law, and I'd like to extend a very warm welcome to everyone here present. Particularly warm welcome to you, Chief Justice Winkelmann is, of course, our speaker for this evening, and a very warm welcome also to our other distinguished guests, including Sir Anand and Lady Susan Satyanand. This year's Taurunga's Public Law Lecture is a particularly special event because we're very pleased to announce that from the beginning of next year, all our law programs from the law faculty will be offered at Tauranga campus along with Hamilton campus. So this means that students enrolling in law at Tauranga will be able to study everything from our LLB right through to our PhD in law. And we did actually run an information session earlier today, but we've got members of the law leadership group and the management groups. If you would like any further information about our offerings next year, please do come and speak to us after the lecture. This year is also a particularly special event for us, or year for us really, because we've been celebrating our 30th anniversary. Although we turned 31 this year, the faculty has been celebrating a number of our postponed birthday events from last year, this year, because of COVID. Our faculty was founded in 1991 and is now one of Aotearoa, New Zealand's leading law schools. We are now ranked in the top 300 law schools in the world in the QS World Rankings and have more than 4,000 alumni worldwide. Our faculty is also a leader in a number of areas of legal research, including Maori and Indigenous legal systems, environmental law, and also technology and future law. And since our very beginnings, we've always looked to push the boundaries of our three founding principles: biculturalism, professionalism, and legal contextualism. And to draw upon a fairly recent example, earlier this year, the New Zealand Council of Legal Education, our regulating body, mandated or passed a resolution that all LLB core subjects would need to have embedded in them tikanga Māori concepts. And although this might have been seen to be a fairly bold move in some parts of the motu, this is something Te Hūnga has been doing for 30 or so odd years. And similarly, you'll see the slide behind me and some flyers in the room tonight. The Te Hūnga's Law App for the New Zealand Law Style Guide is the first such legal referencing app in the country, and again demonstrates our innovation and drive to set new standards and to think differently. I won't take up any more time. I'm conscious that I'm standing between the main event. Thank you very much again for coming tonight. Particular thank you to you, Judge, for being our speaker this evening, and of course to our partners in co-hosting this event, Mackenzie Elvin Law. It's been an absolute pleasure and delight working with Mackenzie Elvin Law, and I'm sure this is a relationship that will strengthen and continue for many more years to come. I'd now like to invite Marcus Wilkins, partner at Mackenzie Elvin Law, to the stage. Thank you all very much again. Ngā mihi nui.
Kia ora tātou, taku ingoa Marcus Wilkins. Kei Mackenzie Elvin Law, aho, mahi ana ngā mihi nui ki ngā rāhu ahurei o Tauranga Moana, ngā mihi nui ki koutou katoa. Ki te atua, tēnā koe ki Papatunu Nuku, tēnā koe ki te whare wananga o Waikato, tēnā koe ki te hunga mātai, ki te hunga rā, tēnā koutou, tēnā koutou, tēnā koutou katoa. My name is Marcus Wilkins. I'm a partner at Mackenzie Elvin Law. It's my pleasure to welcome you here this evening to the second lecture we've conducted with the university, and I'd echo the sentiments that Elvin has shared with you. It's good to see we've got a full house. I see members of the profession, members of faculty and university staff, law students, saw at least one, clients and members of the public. I also want to acknowledge we have a number of our local district court judges here, Judges Cook, Coyle, Gagan, Ingram, and Judge Hollister-Jones and Judge Munro from Rotorua, and I haven't seen her tonight, but Caroline Silk, the Vice President of the Law Society. There she is. Thank you for coming this evening. It's nice to have the Law Society represented here. Nice to see the Law Society in Tauranga Moana, actually. Thank you. So why is Mackenzie Elvin Law putting this lecture on? The simple answer would be there's now a campus here and the university is offering a 4-year degree, but it's a bit more than that for us as a firm. We believe we've got an obligation to support the law faculty and the university as the critic and conscience of the nation, which is the role of a university. We also understand and defend the critical importance to the liberty of all of us that comes with an independent and fearless judiciary and an independent and fearless profession. The importance of these roles of both the university and the judiciary as the third branch of government is lacking, in my view, and the understanding in New Zealand because we don't have civics education. So we see public lectures such as this, participation with the university as the critic and conscience of the nation, as being one of the things that we can do to ensure that those important things aren't lost as generations pass. So, housekeeping. I'm sort of the MC tonight, so I need to tell you this sort of stuff. The bathrooms, if you haven't found them, are out there and down the end of the corridor. If there is an emergency, there are exits here and at the back. If you haven't already done so, turn your telephones off, unless you're like me and you've got hearing aids and you need your telephones to run your hearing aids. The lanyards that you've got around your neck, you don't really want to walk out of here and wander around town, so there'll be people who can take them after the event. So the format for the evening from here is my colleague and partner at Mackenzie Elvin Law, Rebecca Savage, will introduce Her Honour, and Her Honour will then address us. There's opportunity, Her Honour's graciously agreed to take questions. That will be moderated by another Mackenzie Elvin Law partner, Thomas Refoy Butler, and then we'll conclude with our other Mackenzie Elvin Law partner, Dr. Fiona Mackenzie, to offer thanks and concluding remarks. So that's the format for the evening, and I would like to invite Rebecca up to introduce Her Honour. While she's doing that, I will just point out for members of the profession that Her Honour is a contributor to Challenge and Change, judging in Aotearoa, New Zealand. Good read, actually. Burrows and Finn, they were my lecturers at Canterbury University years ago, and but Her Honour's a contributor, so get to your nearest legal publisher and buy this book. Or else go to Books of Plenty and they'll find it for you.
Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Rebecca Savage tōku ingoa. No Tauranga Moana o Kutupuna. Ke te noho ao ke te puna. E hara tā kuto. E te toa takitahi. E toa takitini. My strength is not as an individual, but as a collective. I'm a partner at Mackenzie Elvin Law, and in partnership with the University of Waikato, it's my absolute pleasure to welcome our current Chief Justice to present the lecture tonight. The Honourable Justice Winkelmann is New Zealand's 13th Chief Justice and was sworn in as the current Chief Justice on the 14th of February 2019. She grew up in Auckland and attended Linfield College. She studied at the Auckland University and completed her studies in history and law. During this time, she was awarded the Auckland District Law Society Centenary Prize for Best Undergraduate Degree. She was then admitted to the bar in 1985 and joined the firm that was known as Nicholson Gribbin and is now known as DLA Piper. She was the first female partner and the youngest ever at that time. Justice Winkelmann joined the independent bar in 2001 and specialised in insolvency, commercial litigation, and medical disciplinary litigation. She was appointed to the High Court in 2004, became the Chief High Court Judge in 2010, and was then appointed to the Court of Appeal in 2015. Her Honour has introduced significant reforms to improve accessibility, timeliness, public understanding of the work of the courts, and the incorporation of te reo into court procedures. And tonight we have the privilege of hearing directly from Her Honour on the issue of access to justice. He iwa ki te poa, he paiwai ki te ao. Rain at night, eels at dawn. Nō reira, Justice Winkelmann. Tēnā koe, tēnā koutou, tēnā tātou katoa.
Tauranga moana, tauranga tangata, mihi mai, takitimu waka, mātātua waka, whakatau mai. Ngāti ranganui, Ngāti rangi, Ngāti pūkinga. Karanga mai, e mihi ana kinga mate o te wā. Kia koutou, Te Hūnga Ora, ngā marae kura, ngā mana kura. Ngā huia tūrei o te turi, kua hui hui mai. Tēnei rā mihi mai o hā kia koutou. Tēnā koutou katoa. Well, I'm delighted to be here in Tauranga this evening and honoured to be speaking as part of this lecture series. Thank you very much to Te Whare Wānanga o Waikato and to Mackenzie, Elvin Law, and thank you, Marcus, for that promo of that book. I've described it myself at the book launch as a cracking read. It's a good read. It's a good read for anyone, even people who aren't lawyers, possibly, especially for people who aren't lawyers, because it dishes the dirt on the judiciary. So, when I was asked to speak, it was suggested that I revisit the topic of a talk I gave in 2014 as part of the lecture series which honours New Zealand's first woman who's admitted to the profession, Ethel Benjamin. And the title of that lecture was a little bit facetiously, Access to Justice, Who Needs Lawyers? Convention in our society at least suggests that you revisit things on decimal basis at 10 maybe or 25-year intervals, but I agreed to do so at only 8 years for several reasons. First, because I believe the need to preserve social cohesion makes securing access to justice more pressing today than it ever has been. And secondly, as Chief Justice, I've had many opportunities to reflect upon access to justice issues within a broader framework, and I'd like to share the perspectives that I've gained in that role. And finally, because recent developments give cause for optimism that we can make progress in this area, and we all need a little hope. The title of my speech tonight is Access to Justice, We Need More Than Lawyers, so it speaks a little bit to my 2014 lecture. When I spoke in 2014, I made the case for ensuring access to justice in the civil area, and I made that case in rule of law terms. I said that access to justice was the critical underpinning of the rule of law. In a society ruled by law, everybody, the good, the bad, the weak, the powerful, exist under and are bound by the law. And I said that condition cannot exist without access to courts. The focus of my 2014 address was on access to courts and access to lawyers. But I was speaking at a time in 2014 when access to the courts seemed to be viewed by government in market terms. Rather than portraying courts as a critical democratic institution, civil courts were depicted as a luxury service for which users should pay. I noted some of the language at the time. People who came before the courts were referred to as customers. District court centres were referred to as franchises, and judges and lawyers were stakeholders. And I also spoke at a time when lawyers were framed as barriers to, rather than enablers of, access to justice, a framing which led to family court reforms, curtailing the right to legal representation in some legal proceedings. And there was also at the time a reduction in legal aid funding and an effective freeze on legal aid thresholds and rates. I'm pleased to say a lot has changed in that regard over the last 8 years. The reforms of the family courts which limited access to lawyers have been repealed. There have also been some improvements in connection with civil legal aid, a point I return to shortly. The consumerist language in relation to the civil courts has largely disappeared. The Ministry of Justice has identified access to justice, including civil justice, as an enduring priority. This commitment has found expression in many ways, including through the Secretary for Justice joining with me in sponsoring the development of a strategy to facilitate civil access to justice. That strategy is entitled Wayfaring for Justice, and it's a strategy which reaches beyond the courts. And again, I'm going to return to that later in my talk. These are all important developments, but they're not what I speak of when I say that a lot has changed since 2014. With hindsight, 2014 was a relatively benign period for the institutions that support liberal democracy throughout the world. There was a broad consensus in the West as to the political legitimacy of democracy, and by today's standards, little serious challenge to the legitimacy of the institutions that support it. As Sir Geoffrey Palmer has recently observed, that benign period has very much come to an end. The political legitimacy of democracy is under challenge in many places throughout the world. Sir Geoffrey quotes the 2020 report by the Centre for the Future of Democracy at the University of Cambridge, which concluded that dissatisfaction with democracy has risen over time and is reaching an all-time global high, in particular in developed democracies. Associated with this dissatisfaction, or perhaps driving it, the cause and effect is difficult to unravel, is the growth of populism. The characteristics of populism are an appeal to the wisdom and power of the people and a questioning of the legitimacy of institutions by characterising them as elitist and not of the people. Populism typically presents the world as divided into good, the will of the people as expressed through populist leaders, and evil, anybody who is not entirely in agreement with the will of the people so expressed. In this black and white world, compromise is impossible. Given these characteristics, the rise of populism is often associated with the undermining of democratic institutions and perhaps even the rise of authoritarianism. Sir Geoffrey notes the very many countries in which a tendency toward authoritarianism is now discernible, and some of the countries he lists would surprise you. But populism is not a new phenomenon. Whether we think of it as a political strategy or a political theory, it has been democracy's persistent shadow. As long ago as the time of Cicero, some candidates for consulship in Rome, ancient Rome, were described as populare, meaning that they appealed to the people for their votes by decrying the elite as self-serving. A study of history shows that populism ebbs and flows. Today, it is fair to say that it is at full flood in many countries. New Zealand has stood apart from the worst of this. I believe we are lucky in our institutions. New Zealand ranks highly in rule of law terms, a fact in large part based on the integrity, standing and ability of our judiciary, and that's not just me saying it, but our Minister of Justice. But we can't be complacent. As American constitutional Cass Sunstein has said, in all democracies there is a constant source of deliberative trouble. Political disagreement can be heightened simply by virtue of the fact when like-minded people are talking mostly with one another. They are most likely to end up thinking more extreme versions of what they thought before. It follows that if like-minded people are talking mostly with one another, social fragmentation is highly likely. New technologies, including the internet, increase this risk. In the words of Cass Sunstein, in the worst cases, hatred and even violence are possible consequences. One of the critical features of populism is the sense amongst those captured by its appeal that democratic institutions do not respond to their needs. Again, this is both a cause and effect of populism. Democratic institutions anticipate this risk by ensuring that they tend to the source of their legitimacy. The legislative branch does this by responding to the vote of the electorate. The judicial branch maintains its legitimacy through the process of fair hearing and judgment. In other words, the provision of forums in which conflicting views and claims are able to be explored in a solemn and dignified manner and resolved through the equal application of the law as evidenced in the giving of reasons. The performance of this role demonstrates in a tangible way equality before the law as an ideal to which our society subscribes. Each society inevitably falls short of that ideal. However, a society whose institutions no longer work toward it and whose people do not believe that there is equality before the law is a society in which social cohesion will be loosening and civil society deteriorating. 8 years on from 2014, therefore, I believe that the case for focusing upon and indeed fighting for access to justice in order to support the rule of law is more pressing than ever. Access to justice has two strands: ensuring that people have access to the institutions and procedures that will uphold and enforce their rights, and ensuring that people have access to the content of the law. That is, that they understand their rights and how to access and enforce them. Tonight, I address both of these strands, but I broaden my focus beyond the courts. So that's different to what I did in 2014. Then I focused on the courts. Tonight, I look beyond the courts. And there are two key themes I explore. The first is that those involved in the work of administering justice, in its broadest sense, must listen to the voices of those who need to access justice or who have experience trying to do so. This is the best source of information about how services should be structured and delivered. It is an approach that also ensures that the institutions involved in the administration of justice remain connected to their communities. The second theme is the need for a systemic focus upon supporting access to knowledge of rights and duties and to lowering barriers to being able to enforce them. And by systemic, I mean across the courts, across the profession, and across government. In other words, to use the title of this lecture, we need more than just lawyers. My address is therefore going to be wide-ranging, and inevitably, I'm afraid it's going to be superficial in its treatment of some of the issues. It forms something of a to-do list, although some of the tasks on the list will not be, indeed cannot be done by judges. So a good starting point is the nature of the obstacles that stand in the way of those two aspects of access I have described. We're helped in understanding these obstacles by the Access to Justice review currently being undertaken by the Rules Committee. And for those of you who aren't court lawyers, the Rules Committee is a statutory body set up under the Senior Courts Act, and it works across the executive and the judiciary to create the rules of court for the District Court and the High Court and the Court of Appeal and the Supreme Court. And I see a former Rules Committee clerk sitting back there, Sebastian Hartley, who knows this all intimately. When I mention the Rules Committee to some of my colleagues on the Supreme Court, they start groaning and moaning, but it's an incredibly important committee, as I'm sure Sebastian would back me up on. And in 2019, it embarked on an Access to Justice review of the District Court and High Court rules. It was sold to the community and to the profession as a once-in-a-generation review, and it wasn't oversold in that regard. The review was initially focused on improving access to justice, civil justice in the District Court and in the High Court through rule reform. Although the focus was at first upon rules, the feedback we got through consultation threw up broader issues, so that with the agreement of the Attorney General and the Minister for Justice, the review has expanded to address some questions of policy and legislative reform. You'll be pleased to know I'm not going to take you through the proposed rule changes, but what I am going to do is take you through some of the submissions to the Rules Committee we received, because they are a rich source of information that can assist us in understanding the barriers that exist in the way of accessing courts and tribunals, and the barriers in the way of obtaining information about the law. I really am very grateful to all who submitted. That included many law firms, individual lawyers, academics, and it included community law centres throughout New Zealand, and citizen advice bureaus. The Law Society described a justice gap. The justice gap is the measure of people who have justice needs but cannot access help for them. They described a justice gap which has been building for decades. Many submitters described the obvious barriers created by costs, substantial costs of court fees and hearing fees, the still more substantial costs of legal representation. As Dr. Bridget Toy-Cronin has highlighted, in recent years, the increase in cost of legal services has far outstripped the increase in median weekly income. The cost of legal representation before a court or tribunal is such that civil litigation is beyond the reach of even middle-income New Zealand without the assistance of civil legal aid. And I don't need to cite anything for that proposition. It just follows inevitably as a matter of logic from legal charge-out rates north of $300 per hour, and therefore legal aid is critical. But the eligibility rates for legal aid are still, notwithstanding recent increases, set far too low. falling well short of middle income. Moreover, as the Otago Legal Issues Centre documents, very few lawyers are prepared to take on work from legally aided civil clients. And that's notwithstanding a very high level of commitment to providing access to justice across the profession. But the low rates are such that when you combine them with a very high administration load, it's simply unsustainable for many law firms to do the work. The submissions we receive from community law centres provide powerful insights into how courts and the profession and the law is seen by those who have pressing justice needs. The themes identified echo the results of various surveys and research has been undertaken. Both quantitative and qualitative assessment comes to the same conclusion, but it's the qualitative I want to talk about tonight because it provides a narrative that tells the human cost. Those making these submissions are expert. These are submissions from the community law and citizen advice, are expert not only in the operation of the justice system, but also in the difficulties that the marginalised experience on a daily basis. And for this reason, it is information we need to pay close attention to. Porirua Kāpiti Community Law Centre highlighted the cultural barriers to interacting with the courts, noting that many of its clients experience whakamā, feelings of shame, inferiority, inadequacy, embarrassment, and self-doubt. The Waitemata Community Law Centre highlighted that this is particularly problematic for Māori who find the current court system alien. Given the historical impacts of colonisation, their expectation is that they will not be listened to or respected in the justice system, so why bother? The Porirua Kāpiti Law Centre observed that for the centre's clients, not only those of Māori descent, but also Pacifica, migrants, refugees, and others for whom English is a second language or who lack formal education, the court system is difficult to engage with. They noted, and I quote, "The Eurocentrism and bureaucracy which dominates the legal sphere does not reflect New Zealand's population. Accessing justice can therefore be an alienating experience for those whose cultures do not reflect the dominant values of New Zealand's legal system." Community law centres reminded us that many of their clients with very real civil justice needs are living with mental health problems or experience ongoing mental health illnesses. Many who come into the court system have disabilities, but the court system makes little provision for the disabled, either in the information we provide or in the processes we use. This makes it difficult to access or participate in civil justice. Community Law Waikato said that their clients are generally the marginalised, vulnerable, and are living on low incomes. Often they have had limited education, but they have pressing justice needs. Even the few who do manage to engage with the processes often come out the other end simply not understanding what has happened. Community law centres, including Community Law Canterbury, emphasise the absence of accessible and comprehensible information about rights in the areas in which their clients' problems often arose, including debt arising from interaction with finance companies and door-to-door sellers, or from an inability to access benefit and accident compensation entitlements. Many submitters referred to the technical jargon-driven way in which information is presented in all aspects of the court process, rules, court forms, and even judgments, and all of the lawyers in this room who work in the courts as judges or as counsel are guilty of this. The use of inaccessible language makes engaging with the courts and understanding what is required of the litigant difficult and daunting. There is, we are told, an obvious need for accessible, clear, and to-the-point information to enable their clients to understand their rights and how to access them. These submissions are all available on the Rules Committee website. What emerged for me when reading them is how important community law centres and citizen advice bureaus are in enabling access to justice. I really am humbled by those who volunteer for or who work in these centres. What is critical for my purpose tonight, though, is that these submissions are evidence of serious barriers to accessing our courts for those with the most pressing justice needs. They describe a court system which is alien to their clients, which remains Eurocentric, even though we live in a country in the South Pacific, and in which communication occurs in complex and obscure language and processes. The alienation of the vulnerable in our society risks a weakening of social cohesion, allowing populist ideas to take hold in the spaces left by the justice gap. If people do not see the courts and tribunals as institutions that will respond to them, then they will look elsewhere. As I stand here and recite those submissions, it's actually quite hard to recite them. I think it's an emotionally moving account of what is going on in our society, and it presents a daunting list of issues for us to address. These submitters describe the complex interplay that takes place between procedural and substantive law, and the vulnerabilities of many in our society, which leaves them unable to seek the protection of the law. We can't expect community law centres or citizen advice bureaus to bear the full burden of closing that justice gap, no matter how vital their work is, and their work is vital. The Rules Committee will report shortly, but given its focus, it can also only be part of the solution. I don't want to oversell the Rules Committee. We have a judiciary which sees and is committed to addressing these challenges, but many of the issues that exist are beyond the power of the judiciary also. We need the Ministry of Justice work alongside us, and I'm pleased to say that we have that. We need the profession alongside us, and I believe we also have that. But we need more than the profession. The government as a whole needs to be alive to these issues. I therefore turn to highlight the work that's underway to address these concerns and the work yet to be done to achieve the systemic response that I believe is necessary. And I'll just pause for a drink of water. First, cost. The cost of accessing justice, the cost of legal representation, and even the cost of filing and hearing fees. That's a big obstacle, but unfortunately it's beyond my powers as Chief Justice. You set the legal costs, and the Ministry of Justice sets the filing and hearing fees. In the past, I have been outspoken regarding the deficiencies of our present legal aid settings, and that certainly is a big obstacle. In early August, the government announced extra funding to raise the eligibility threshold, reduce the numbers subject to repayment obligations, and increase legal aid rates for lawyers. While I was pleased to see this, it's obvious that with only a 15% increase to eligibility thresholds and with legal aid rates for lawyers to criminal defence lawyers still nowhere near Crown rates, this is not the reset the system needed. Having said that, I must acknowledge that all jurisdictions, common law jurisdictions, struggle with the delivery of a sustainable, fair, just and accessible legal aid system. The UK House of Commons Justice Committee, which is a cross-party committee, acknowledged a similar reality, and they recently suggested a review of their legal aid framework to enable aid to be targeted to areas most in need and best calculated to improve the effectiveness of the courts and justice system. I also suggested our legal aid system needs such a review with a similar strategic focus. The system is developed over time, often in response to various historic and political events. A strategic review could ensure that funding is targeted in the areas in which it's the most effective in achieving equitable access to justice. It could also untangle some of the outdated assumptions about the model of legal service that are baked into the current scheme. It's a scheme that's really basically conceives of a profession that existed 20 years ago. And these are assumptions that hinder the provision of effective and efficient services. Such a review can't be tinkering at the margins, however, because I have to acknowledge there have been reviews in the past, but in my view, they are reviews that have really been at the margins of the scheme. And it also must have an access to justice rather than a cost management focus. As much as the funding levels are an issue, so too are the administrative systems. I'm told that many in the profession would rather do the work for free than subject themselves to the form-filling requirements to be approved for legal aid, and then to have their invoices paid, and then there's the audit process as well. We can all share the blame for the administrative system we have today. The profession and the judiciary, for good reason, did not wish to bear it. The Ministry of Justice has been working hard to address these issues. They've been reducing the burdens associated with approval as a provider, and with applying for a grant of legal aid. But it's not enough. I think placing all of the responsibility upon the Ministry of Justice is to ask too much of it. Without up-to-date practical experience of files, law officers, legal practice in courts, it's difficult to maintain an administrative system that is responsive and light touch. That's another area I suggested a strategic review could address. Another area we need to focus upon is supporting individual and community participation in the courts. The community law and citizens' advice submissions I've outlined raise issues as to the alienating nature of court processes and the difficulties of engaging with a formal court system. The courts are developing processes and even courthouses that are more in keeping with a country in the South Pacific, founded upon Te Tiriti o Waitangi, and these courthouses reconceptualise the courthouse as community spaces. These changes are directed at reducing the alienating impact of the 19th century edifices and procedures of our courts. I don't for a moment suggest that we're going to abandon all the traditions that we've inherited from England. Any such suggestion is normally met with wails of protest, not expressed during the lecture, but after a while leave it. There is, I acknowledge, value in much of that process and tradition. Rather, what we need to do is allow those processes and traditions to evolve to meet the particular needs of Aotearoa New Zealand. We are also accepting that new ways of doing things, new at least for the courts, derived from this time and place, can enhance the concept of the fair hearing and the administration of justice. Relevant to this development is Te Ao Marama, the model of justice currently being introduced in the district courts, criminal and family jurisdictions. Te Ao Marama has two focuses. First, upon creating hearing environments that support engagement and comprehension for the people who are the subject of the proceeding, not just the lawyers. This objective is pursued by the use of plain English, through whānau and community presence and support for the parties, and by using community assistance where appropriate. The second aspect of Te Ao Marama utilises the court process as an opportunity to address the conflict or the harm, the hara, that underlies the court proceeding. It does this through community engagement or the support of government agencies or other service providers. Both of these features of Te Ao Marama pick up judge-driven innovations that have been used in pilot courts now throughout New Zealand for over a decade. Although developed in the criminal and now family jurisdictions, the model has obvious relevance to many other areas of the court's civil jurisdiction. Te Ao Marama is supported by the Ministry of Justice, and I believe that these aspects of Te Ao Marama will have their impact on civil justice beyond the area of family over time. But we also have to work to understand our communities, so that's judges and lawyers have to do this work. Judges and the profession need to understand the communities they serve, and they need to also be adequately grounded in te reo and tikanga. Across all courts, judges receive education in te reo and in tikanga. They also receive education that enables them to deal with the diversity of people who come into the courtroom and who need to be supported in full participation in the proceeding. These are educational initiatives that have been in place through the judge school which we have, which is called Te Kura Kaiwhakawa, the Institute of Judicial Studies, for several years, I think about 7 or 8 years. And I suspect that the profession is only just beginning to catch up, but catch up they must. Recently, the Supreme Court issued a decision in a case called Ding and Zhang, which addressed the importance of counsel being aware of cultural context in civil proceedings and being prepared to support the court with those issues. This is a judgment which repays reading. It elucidates how important an awareness of cultural context can be to a substantive outcome, to substantive access to justice, if you will. And it fundamentally highlights how important it is for the profession to be sensitive to different cultural contexts, and perhaps even to be educated about other cultures, as the New Zealand judiciary is today. It was pleasing to see the New Zealand Law Society, New Zealand Bar Association, and New Zealand Asian lawyers respond so promptly to that judgment with the educational imperative outlined there. The focus of the work being done within the courts that I've mentioned is firstly upon ensuring that courts remain connected to their communities and are able to meet the community's justice needs. And secondly, on ensuring that people see and feel that justice administered by the courts is accessible to them. It's critical to ensuring access to the courts in the sense I've described, the ability to bring proceedings and the ability to fully participate in them. It's critical work to ensure that the courts are not and are not seen to be an elite serving only the interest of part of society. But the courts don't have all the answers, and so I now turn to addressing access to justice issues beyond the courts. And I first mention in the area of tribunals and also statutory dispute resolution. In our society, the reality is that most access to civil rights occurs in tribunals or through other statutory-based dispute resolution processes. Aside from relieving the court system what would otherwise be a crushing workload, these bodies and processes are typically set up to allow resolution of disputed claims, those claims often to statutory entitlement, using more informal processes than is permitted in the courts, and often in the statutory review processes also using alternative dispute resolution processes. Given the volume of the civil disputes and entitlements resolved through these means, we are wrong to keep our focus solely upon the courts and lawyers when we think of access to justice issues. Barriers to access to justice can arise just as surely when these other processes are not understood or are difficult to engage with. And I offer an example of the system responding to this challenge. In July of 2015, the Minister of Accident Compensation and Minister of Justice had announced a reform of the accident compensation system to reform their appellate pathways. They were replacing appeals to the district court with a specialist tribunal. But that proposed reform was put on hold when the then Minister of Accident Compensation and Minister of Justice received a report from Acclaim Otago Inc. Acclaim is a support group for injured New Zealanders and their families which advocates for systemic change to improve the lives of injured people. In its report, Acclaim described the barriers that some people face when challenging ACC decisions. And it has to be remembered that ACC decisions are often incredibly important for people. They go to support their entire livelihood and their wellness. The report was based upon a wide-ranging review of case law and case studies, but it drew upon the report writer's extensive experience in the field. It provided a detailed account of the process showing how obstacle-strewn and distressing engagement with the dispute resolution process was for those who wished to challenge ACC decisions. The report was funded by the Law Foundation and by the Otago Faculty of Legal Issues Centre. The report's conclusions were compelling, and they reflected, which I'm sure reflect the expertise of the authors and the system they criticised, and the detailed knowledge they had of the difficulties faced by those who had to interact with that system. It must have been something, well, I read it and I actually wrote the foreword for it, so I know it did have an impact, and it certainly had an impact on the ministers, because in a very unusual move, the ministers immediately responded by cancelling the proposed legislative changes. Instead, they committed to consulting with injured people to understand their experience of the system. And following an independent review which confirmed most of Acclaim's criticisms, ACC and IMBI have worked to address these obstacles. They've invested in providing better and more accessible information. They've invested in the creation of alternative dispute resolution pathways and in a free navigation service providing support capable of advocating for claimants' interests and assisting them to raise disputes or complaints where appropriate. So this really is an example of engagement and responsiveness, a redesign informed by the unique insights provided by a claim speaking on behalf of the people affected by the process. In a more recent report, Warren Forster, who was one of the original authors of the acclaim report, observed the significance and early promise of this work in transforming the way people experience disputes with ACC. So I take several things from this example. First, it demonstrates how effective it can be when the system listens to and engages with the voices of those who most use it, who must use it. To link back to my earlier discussion of populism, this can provide an opportunity for people to be engaged with their institutions. Secondly, it highlights how vital it is to have organisations or advocacy groups with the knowledge and expertise to collect and channel these voices and so enable this engagement. Those who operate the system, lawyers, judges, are experts in it, but we struggle to understand what it is like for the novice to engage with it. It's because of our expertise that we struggle to understand what it's like for the novice to engage with it. Feedback such as ACC received from Acclaim and such as the Rules Committee received from community law centres and citizen advice bureaus is to be treasured. And thirdly, a related point, but also a bit of a digression, the claim report and the more recent report by Mr. Forster demonstrate how important funding for this research has been, and we have 3 organisations that have been funding Access to Justice Research New Zealand. We've had the Otago Legal Centre, Law Foundation, which is has gone into funding recess, and more recently the Boren Foundation, and they do incredibly important work. So if they were doing a fundraising drive, please give generously. And finally, I wasn't intending to say that, but it's spur of the moment. And finally, this is a useful example for me to springboard to my next point, which is how effective and indeed vital a focus on access to justice within government departments is. Traditionally, it's judges and lawyers and the Ministry of Justice who are the advocates for and guardians of access to justice. I believe that access to justice is a concern with which all government agencies should actively engage. Most rights and obligations are sourced from statute and accessed through government departments. There's a compelling case for making access to justice a structural focus for all government departments. First, access to the benefits of English citizenship guaranteed to Māori under Te Tiriti included the benefit of the law. Secondly, as I've set out above, access to justice is vital to social cohesion, and as study after study has recorded and observed, to the economic growth and prosperity of a nation. That's a point even economists can understand. And attending to access to justice is simply a democratic imperative. It's a positive innovation that MB has now established a government centre for dispute resolution principles. And again, you can search that on the internet. It's quite a read. It's fascinating information. The purpose of the centre is to provide principles and information to assist government departments to design dispute resolution processes. I would like to see a similar agency supporting access to justice across government, which would focus on both of the aspects of access to justice I mentioned earlier: access to knowledge of the law and access to the means to enforce rights. A government-wide focus of this nature could be transformative in terms of access to justice and toward building a more just and equal society. There are 2 obvious areas for it to focus upon. First, the content of legislation. When we create legislation to protect the rights of tenants, employees, the injured, etc., we do so because, as a society, we wish those rights to be protected. When drafting critical rights-heavy legislation such as the Residential Tenancies Act, Employment Relations Act, and Accident Compensation Act, an early focus upon how ordinary people will be able to understand those rights seems sensible. It would be valuable for such legislation to be written for those who use it. Each of these pieces of legislation is complex, with lawyers and judges having to work very hard to construe them. Some of this complexity is surely avoidable. Great strides would be made towards access to justice where legislation designed to facilitate not only comprehension, but also enforcement of statutory rights. How rights and obligations are described and how statutory provision is made for their enforcement impacts directly upon how easily understood and how easily enforced they are. Self-evidently, that's true, but it's worth saying. Expressing rights in complex or vague terms sets up the likelihood of dispute. Rights which are only enforceable through the courts will be out of the reach of many, and many more may not even be aware that they have rights. I'm not sure if it's a legislative design principle to focus upon how statutory rights will be understood and enforced by lay, non-legal people of limited means, but if it's not, it should be. Certainly, I'm not the only person to think this. The Law Commission recommended as long ago as 2008 that legislation be accessible, built on principles of availability, navigability, and clarity for users. And to their list, I would add enforceability. The lessons which have been learned from ACC will be useful here. In his book, Making Laws That Work, Justice David Goddard gives other examples of simplified low-cost mechanisms that allow people to challenge determinations, but which do not remove the right ultimately resort to the courts, because that right is important. The courts are the underpinning of the liberal democracy we exist in. Another critical area of focus must be on providing easy access to information about rights and dispute resolution pathways. Community law centres and Citizen Advice Bureau have led the way in this area for a long time in Aotearoa. Several government departments and agencies are now also making considerable and commendable efforts to provide online legal information, but this information typically provides only a part of the answer. The guidance is not given, which is needed to navigate all the way through from identifying that you have a right through to resolution. That's understandable given the very many different factual and procedural permutations the information needs to cater for. In 2020, David Turner and Bridget Toy Cronin released a report on legal online information self-help in Aotearoa, an agenda for action, which identified this difficulty with existing resources and emphasised the need, drawing on lessons from other jurisdictions, to take a whole-of-jurisdiction approach. They concluded that a strategy of cooperation and user engagement is necessary to achieve this. In their view, this cooperation would require the coming together of people from across the judiciary, legal profession, and community. I suggest, however, that real progress will not be made until government agencies are also engaged in this work, because it is that engagement that will create the opportunity for simplification of process and information, and which will lead to the design of user-focused legislation. To use the language of ministry, we need a joined-up solution. And so on to my last point tonight, which is hope for the future. There are signs that institutions and systems are responding to the calls for better access to justice. There are many green shoots in this area. Access to justice is certainly now a focus within the profession. The New Zealand Law Society recently led a large-scale review in the area, which has provided vital data. The measure of what legal excellence is, as expressed through the criteria for appointment as Queen's Counsel, has been amended to include the work that the lawyer does to facilitate access to justice. The 2021 establishment of Te Ara Ture, the pro bono clearinghouse, launched as a subsidiary of Community Law Centre Aotearoa, brings together a database of lawyers willing to offer pro bono service. This is an important initiative funded by the Ministry of Justice. So that's a list of things that are happening that are good. Good also is the wayfinding for civil justice strategy I mentioned at the outset. The draft strategy, which I think is still open for consultation, proposes the establishment, alternatively the strengthening, of an existing body to coordinate reporting of access to justice initiatives and the sharing of information. The draft strategy document states that wayfinding will be successful if everyone is aware of each other's efforts and all the efforts are contributing to meeting the strategy's goal. The goals are stated to be increase community access to legal information and self-help tools. Second, increase the availability of affordable legal services, and increase lawyers' knowledge and understanding of communities and their needs. Third, increase the availability of information about the range of dispute resolution mechanisms that are available, and ensure equitable access to the courts. And finally, increase knowledge of how the system is currently operating, and evaluate and monitor innovation and change. The working group responsible for the creation of the strategy has provided a model of cross-sector thinking and leadership. Through information sharing, the strategy aims to make the significant efforts of individuals and organisations that are already underway to improve access to justice more effective by creating the opportunity to learn from each other and by creating opportunities for coordination. And so I conclude. Although there are challenges to improving access to justice, we must rise to meet them. Doing so is a democratic imperative. Improving access to justice has never been more pressing than it is today, given the need to maintain social cohesion in the face of rising populism throughout parts of the Western world. There is much to be done. Judges and lawyers have their role to play in this work, but more than lawyers are needed if we are to make meaningful progress. A structural focus on access to justice across government, across the judiciary, and across the profession is required. And as we do this important work, we must continue to listen to the voices of the community. We must listen to the community if we are to meet the needs of those we serve. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. I think I stay here for questions, do I?
I can just run out with this.
Someone, the audience is more likely to need the mic.
Yeah, I'm carrying the mic. You're moderating. You're moderating.
Microphone.
Or you can use them.
No, I'll leave Her Honour to... there will be. Good evening, everyone. My name is Thomas Refoy Butler. I'm one of the litigation partners at Mackenzie, Elvin Law. Firstly, huge thank you to Your Honour for joining us this evening. I know, and I hate to think how busy your schedule is, so it's an absolute privilege for you to be here tonight. Personally, I found your discussion insightful and timely in thinking about access to justice going beyond the courts. And no doubt a timely reminder for the practitioners in this room in thinking about how we can provide access to justice for those who do not have the necessary means to have a say in the court process. We have allowed 10 minutes this evening for Q&A, and given our guest speaker, I'm going to do my absolute best not to breach that timetable. So before we go to the floor, I may try and get one of my own questions across the bow, because I have the microphone.
It's an
abusive process, abusive power. Already across. Your Honour talked about the encouragement and focus of the courts to take cultural values into account in determining disputes. With this in mind, is there now a need, and does it necessitate the need for expert evidence on cultural nuance in commercial litigation and family disputes?
That is a case-by-case basis, and the Supreme Court indicated in Deng and Zhang that the circumstances in which it would be appropriate, and you can all access that on the court's website, and it's right at the end, so it's an easy read. And it said that yes, on occasion it's appropriate, but the court said that it's necessary to do the work to understand whether it's an issue, and in that case, there was an issue, but it wasn't really highlighted by the council all the way through, so the Court of Appeal had to do its own work to pull together the necessary facts from the evidence which had just happened to be there. It wasn't really presented as such by counsel. So it is something that counsel need to turn their minds to.
Thank you. And before I follow up with my own burning issues questions, we'll go to the floor. Reach around this side.
Thank you very much for your talk this evening. Full disclosure before I ask my question, I'm the President of the Arbitrators and Mediators Institute of New Zealand, and the question that occurred to me throughout your discussion was, where do you see mediation in particular fitting within access to justice, in particular given that you referenced that one of the things that we should be aiming for is to deal with the hara, the harm that comes not only in family and criminal but also in civil justice. And a second question, if I may, and if you have time for it, in civil litigation, one of the civil disputes, one of the cost-effective ways of dealing with civil disputes has been the example of the Construction Contracts Act. And do you think that has wider application? Thank you.
So the first question, mediation. Yes, it has an important role to play. It does play an important role, so long as it's used in a way, so long as it's done by skilled practitioners who don't end up with too much skin in the game. Existing imbalances in power can easily be carried into the mediation room, and that's why I say you need skill as a mediator. You need to be able to spot that. And so it has to be used advisedly in some circumstances, for instance, in the family circumstance, family property relationship, or other family breakup circumstances, child care arrangements. You need to get great care in it. But of course, I mean, mediation already plays a vital part in our civil justice system. And many years ago, I spoke against the language that was used at the time to promote mediation, which was basically saying how terrible the court system was. But I didn't when I said that. I said that that we shouldn't say how terrible the court system is, because mediation actually only works if you have a court system that is there developing the law that people can settle against. So they work very much symbiotically. And yes, there are. Your second question. Yes, there is real opportunity for different methods of prompt resolution of disputes, and there are all sorts. Quite a few of them are discussed in that book I mentioned, Making Laws That Work. Another example is child support payments. They're now, if you dispute a child support payment that's made, you can now review it, and an algorithm decides whether it's the correct payment that you're being required to make. But there's an easy way to, which sounds terrible, algorithms, but there's an easy way to escalate that dispute to the next level and get a human review. So it's just a stepped thing, so it's less daunting. And in some ways, actually, people find an algorithm less daunting than having to face up to a human being and make their case. So we need to design these dispute resolution processes with knowledge of the human psyche, really.
Thank you very much. Very interesting. My question really is around who is going to be the, I suppose, guardians of the guardians, because there is an expectation that the professionals go into these processes being fully aware of what they should be doing. But I know of instances where we've had solicitors come into conferences and they don't even get the Māori names pronounced right. They just go through the process. So who do you see as being the gatekeepers or the standard keepers in this area?
Standard keepers for who?
For the profession, because they're going through the procedure, they're following the procedure. but they're just slapping it together in some cases. So you talk about, I'm just talking about experiences that we've had with some of our colleagues, and they go into these family conferences with OT and some of the family lawyers, and they don't even pronounce the names correctly. They just go through the processes. So who do you see as the guardians over this?
Well, we're all each other's guardians, aren't we? It's a matter of acculturating ourselves to perform better. I don't think it's a question of kind of guardianship in the sense of, in disciplinary sense. It's simply that we are growing up as a profession to realise that we're working in New Zealand, and that there is tangata whenua. So it's simply, we can all encourage each other to do better. And we've had that occur in the courts where senior counsel have taken aside a counsel who's absolutely mangling names, etc., and suggesting that they get some help, and they've gone and got help with their pronunciation and with acquiring a basic understanding of te reo. And let's face facts, most people in their 40s and 50s aren't going to become fluent te reo speakers, but there's a level of respect that is involved in speaking, in pronouncing Māori names, and in pronouncing also, of course, Pacifica names, and every other kind of name. Yeah. So I don't think there's a question of guardianship. I think it's a question of us all collectively helping each other and expecting from each other. I think is probably the point and answer. We should be expecting better from each other. But there's no need, and we lead change by encouragement.
Kia ora tātou, tuatai tau toko i ngā mihi kua mihia i te timatanga o tēnei pō, ki te haukainga, Ngāti Ranginui, Ngai Te Rangi, Ngāti Pūkenga, kia kōrua Buddy me Charlie, tēnā kōrua, o tira ki te wharewananga o Waikato, kia Mackenzie Elvin, whakarite i tēnei pō, ngā mihi nui kia koutou, kia koe judge, he honore nui tēnei, nau mahara mai ki tauranga, o tira kia tātou katoa, i roto i te ao ture, tēnei te mihi nui kia koutou katoa. Once more, just want to support the mihi from earlier today, to the haukainga, to the university, to Piringa, and Mackenzie Elvin for organising tonight. To you, Judge, this is an awesome topic, I think one of the most important for us in the profession. Rather than a question, I want to start with a plug. I'm quite involved in community law, and I appreciate the comments you had on the feedback from community law. In my mind, community law is very much there to tackle a lot of the issues that have been raised. I would suggest that for community law to be successful, it does need support from the profession. And in that respect, if anyone out there is interested in volunteering, please let me know. It's perhaps 2 hours every couple of months. If you're partners and you have juniors, send them along. I see the law school also going full-time, a good place to learn and a good place to help. One thing that I learnt, firstly, in terms of the topic, my observation is that with access to justice, I think it's a given that everyone should have access, for example, in situations where they're facing charges, they're at their worst, everyone should have access to justice. I'd go further and say that it's not just those scenarios. An example I'm thinking of is like with Māori land. You might have people who have Māori land, they don't know what to do with it. They don't have lawyers to step them through the process. And if you were to compare that to someone who has money and general land, it's quite different, the outcomes that they reach. So what I'm thinking is access to justice is more than just when you're at the worst. My question is, when I was working at community law, we always knew there was an unmet legal need. We knew people came to us when they had nothing else. They were at their worst. It was usually too late. I think education is huge, empowering those to help them with their rights. The difficulty is it's quite hard to reach those people. you want to let them know of the services, but it's quite hard to, So my question is, have you had any feedback, or have you had any experience with reaching those parts of the community that, like the unseen, the people who,
Yeah. So I'm going to respond to two things you said. First, about the importance of community law. I'm going to add to your plug, because on Friday I'll be swearing in a new High Court judge, Justice Helen McQueen, and I always talk about the things in those swearing-in ceremonies. I talk about the things in the judge that I believe are important for judges, and I always talk at the moment. I'm talking about how important it is that people have general experience of their community, serving their community through the law. It is a fantastic thing for young lawyers to have the opportunity to work with their community in that way. And you develop an enormous amount of law. When you go and work at community law centres, you discover how little law you actually know. And it gives you an entirely different perspective on the law and the legal profession. And it's great for law firms to send their young people along there. So your second question, do I have any experience of those of reaching the hard to reach parts of community? That is incredibly hard, because even if you have fabulous online, legal information, joined up bot type things, it's always difficult. And that is where Te Ao Marama comes in, because the concept behind Te Ao Marama is to form the connections with community groups, particularly iwi, who know their community, and reach out and help them navigate. And that model is being used in the family court at the moment with navigators. So yes, that is the concept of connecting courts community. That is the essence of it, is to try and reach the hard to reach parts of communities. You might have a shout. I think it's turned off.
Sorry, I'm a litigator, and one of the things that I have recognised over my years is the harm that litigation does to families, emotionally and financially. And I may be walking a fine line here, but I wonder whether there is perhaps another approach, which could be teaching members of the profession perhaps about dispute resolution, and not taking an approach, let's go to court or go to court. And one can, I'm sure there are plenty of lawyers in the room who perhaps can talk about experiences with certain firms, lawyers, whatever, where it seems that the approach is we'll go to court, and perhaps a bit of education on, and it seems to me that there can be, people can forget or don't recognise that harm that is done to people by going to court.
Yeah. What your brings thoughts to mind for me. First is that when we talk about the family court, I think that disputes in the family court can do a lot of harm to families. And the original Family Court Act was brought in with, it was New Zealand's first therapeutic justice model in a statutory form. And I think we failed to deliver that. And I think part of the reason we failed to deliver it was because we failed to educate lawyers effectively what was required of them under that model. If you go back and read the first principal family court judge's speeches, Peter Trapsky, he was talking about how a whole new way of practicing family law was required. And we haven't left behind the combative approach that the profession needed to leave behind. So, yeah. I agree with you that there is real scope, I think, for the profession to have a rethink of it. Of course, there are a lot of practitioners who are doing it really well, and we see the high-profile people who spend gazillions on their relationship property disputes, but that's not the general burden. There are a lot of practitioners who are doing a great job, so I don't want to be heard to say otherwise. I just think that it might be time for the family bar to have a rethink about a less adversarial model, because that was the conception of the family court. And what was the second point? Yes, more fundamentally, I think your question raises the point that I believe, that if you leave to one side the commercial lawyers, commercial litigation lawyers, if you leave them to one side, overwhelmingly, I believe that you could adequately and accurately describe our profession as a caregiving profession. And I think we should start to think about ourselves in that way, because we are helping people and on the constructive side build in a positive way a secure and economically viable life. And when things go wrong, we're helping them to deal with some of the worst moments in their lives. And I believe that's another thing that we should think about when we're educating lawyers, that you are helping people. So you're not out there. It's not all about conflict. Some of it is inevitably conflicting what we do, but we should really conceptualize ourselves in that way, I believe. And I think that would address some of the issues that you mentioned. And I feel another speech coming on that topic.
Okay, thank you. I think we might have time for one more, and you've been waving your hand around, haven't you?
Have you already spotted the person?
Thank you, Your Honour. I've in terms of looking at access to justice, one of the things that's been concerning me, and I guess it's a case you made a comment on, which is the Allen Hall case, about the consequences of the failure of the system, and that seems to double down on the lack of access. But I'm really interested in this. Never thought I'd think about, but in criminal cases, is there now a time to be thinking about a inquisitorial methodology rather than the adversarial, which seems to set the two sides up to win and lose?
Well, I'm one of the world's foremost advocates for the jury system. I believe that it's the participative democracy in our court system. It's the thing that gets people in the community into our court system, and it gives a legitimacy to the decisions that come out of those difficult situations. Which is not to say that there's not space for judge-alone trials, and we can debate at what level the right to a jury trial should come in. But I believe that it's a really fundamentally important aspect, and I would not be advocating for its replacement by some sort of inquisitorial or judge-alone type thing for all trials. Of course, a very significant portion of our cases already are done on a judge-alone basis. Yeah. Right. I think there is time for one. That person there has had their hand up for quite some time. Ask me an easy question.
This is going to be quick, as I know I'm the last question. Thank you, Your Honour, for a really interesting talk. I'm just curious as to your views on those aspects of civil law where there's not a jury, and the statutes now have a lot more subjective values that need to be assessed by judges, and how that is balanced within the case precedent and your recognition, which I think all of us practicing have seen over the last 25 years, where you have a society that's rapidly changing, a society that's maturing and bringing in values, including recognition of te tireti, o waitangi, and other aspects of modern society to reflect New Zealand. How do the judges balance that in terms of consistency so that us as practitioners can give appropriate advice to clients when they are seeking access to justice as to what to expect when they go to court?
Two parts to that question. First is I think there are two parts, because it was quite wide-ranging. But one part, I think, is how do we make sure that judges understand their community so they reflect the community values when they're exercising discretion. And that's, in part, that's to do with who we now recruit as judges. Once upon a time, when I was a law student, there were no women judges in the High Court. And it would be, but it's easy to caricature at times and say, oh, they're all from the same group, etc. But a lot of even so, those judges were drawn from very mixed socioeconomic backgrounds and had quite a lot of experience in life. Today we have a far more diverse judiciary still, not as diverse as I would like it to be, but it is a judiciary that is, the selection process really does look for people who are connected to their communities, who understand their communities, and who have practiced not just in micro specialisations. So that's what, and once they're appointed, we educate them. They have to attend. All the judges here know they don't have to attend, but they're invited to attend some fantastic courses. And we really do have a judiciary that I think works hard to understand their community and feels that they are connected to the community. And that goes all the way up to the top, to the Supreme Court. So the second part of your question was whether, how do we stop discretion being exercised too widely in a way, and you'd like it to be understood that it's exercised in accordance with legal principle, I think. It's a very broad question. Well, that's simply to do with the application of precedent, and precedent is reasoning by analogy. And I think even though you're in a discretionary area, judges reason by analogy, and that does give you the certainty. But undoubtedly, their own views form part of it, which is why, again, looping back, we want a diverse and a diverse judiciary which is reflective of their society. I've answered your question.
Well, thank you all for your questions. I blame you all for this taking longer than 10 minutes. No fault of my own. I only got to ask one. I will thank you, Your Honour. Further insights greatly received. Once again, it's been an absolute privilege to have you here this evening. And I'll hand over to my fellow partner, Dr. Fiona Mackenzie, for her final remarks. Thank you.
Ngā mihi nui ki a koe, Justice Winkelmann. My name is Fiona Mackenzie, and I am also one of the partners at Mackenzie Elvin Law. And I'm tasked this evening with extending a grateful thank you to you, Justice Winkelmann, our very eminent speaker, at this, our second annual Mackenzie Elvin Law Lecture in conjunction with the University of Waikato. And as this beautiful building was being erected in our city over the past few years, and the prospect of tertiary legal education becoming a reality here, my partners and I wanted to find a way to connect the practice of law with legal thought, and then bring that to the people of our town. And so we are delighted that the university has partnered with us in this way, and that you have honoured us by coming and speaking at this event into the issues that are key to democracy and civil society and central to how people live together in community. The law is about more than rules. It is about justice, and it is about how we live, and is foundational to a strong, healthy, free and open society. And that's why thinking about what access to justice means and looks like is so important, and why we are so grateful you came, Justice Winkelmann, and talked to us about this very important issue. And now, please accept this with our sincere thanks. And we have just enjoyed joining together in appreciation of what we have received this evening. Nō reira, Justice Winkelmann, tēnā koutou, tēnā koutou, tēnā koutou katoa.